Today's meeting with opening a hearing on House Bill 2274. We'll call upon the reviser to inform us of the content of House Bill 2274. Natalie? All right, committee, can somebody in the free world of internet let me know whether you hear me or not? All right, very good. Thumbs up. Sorry about that. We're going to proceed with our business of the day and open the hearing on House Bill 2274. We'll call upon the reviser, Ms. Scott, to inform us of the content of this bill.
Thank you, Mr. Chairman. House Bill 2274 increases the criminal penalty for buying sexual relations. Current law in KSA 216421 provides that buying sexual relations is a Class A person misdemeanor and then a severity level 9 person felony when committed by a person who has a prior conviction for violation of that section. This bill would make all violations of this section a severity level 9 person felony. And then the bill makes some kind of technical cleanup changes to remove the provisions related to counting prior convictions, since now there's no need to do that since it's all the same level. And then it also removes the provisions related to city and county ordinances, since there would no longer be a misdemeanor version of this offense. And I can take any questions.
Committee, any questions for the reviser, Representative Heiberger?
Natalie, do you know how long the current penalties have been in place?
Mr. Chairman, let me look at something real quick. I won't be able to tell you off the top of my head. I thought maybe there would be not that many amendments to this section, but it looks like the section was last amended in 2017. I don't know what those changes were, but I can certainly get that information for you if none of the conferees know it.
Representative Carmichael, you have your hand up.
Thank you, Mr. Chairman. Ms. Scott, as I understand it, this relates to purchasing sexual relations and escalates that on a first offense from misdemeanor to a felony. What is the penalty for the other side of the transaction, a person who sells sexual relations?
Mr. Chairman, selling sexual relations is covered in KSA 216419. It looks like that is a Class B non-person misdemeanor.
So were this bill to become law, selling sexual relations on a first offense is a Class B misdemeanor, but purchasing sexual relations on a first offense would be a person felony?
Yes, I mean, I would note that under current law, in buying sexual relations, it's still a little bit higher because that first time offense is an A misdemeanor, not a B. But yes, you're correct. Yep.
Okay, I was trying to figure out the proportionality or lack thereof. Thank you.
Other questions for the reviser? Seeing none, we'll go forward with proponent testimony. Call upon Michael Kagi of Shawnee County District Attorney. Mr. Kagi, you on?
Yes, I am. Thank you, Chairman Jennings and members of the committee for the opportunity to appear before you today and speak in support of House Bill 2274. The premise behind this bill is fairly straightforward. We are engaged in an ongoing struggle against human trafficking. However, all of our efforts to this point have been focused on the traffickers themselves and providing support and services to the victims of trafficking. We have not really done much to address the demand side of this equation. And it is my opinion, my experience based on many years of prosecution and the research that I have seen, that increasing the penalty from a misdemeanor to a felony would be an effective deterrent in targeting a specific population of buyers who engage in this type of behavior. And that would be the 25% approximately of buyers who account for 3/4 of the transactions themselves. These are men who come from means generally. They have salaries that exceed 6 figures. So when we're talking about issues like proportionality, the girl who is selling herself or who is being trafficked, depending on the circumstances, coming from an impoverished background, she has little to no choice in terms of making ends meet. For the buyers, on the other hand, who make up the bulk of these transactions, to them this is a hobby, a passing fancy, something they choose to do in their free time with their disposable income, with little to no regard for what's actually happening on the other side of the transaction. To a buyer in these circumstances, and I have interviewed buyers who have been prosecuted, they don't really consider that aspect of it. As far as they know, this is a willing participant, and that's where the equation ends for them. They give money, they receive sexual favors of some kind, and they move on with their day and come back. So if we're going to discourage human trafficking as a business, it stands to reason that discouraging a significant portion of the consumer base that feeds this activity follows, and that's why I'm supporting this bill. And I'd like to thank you again for the opportunity, and I'm happy to answer any questions.
Thank you for being here today. Mr. Kagi is the only proponent testifying here today. Committee, any questions for the district attorney? Representative Carmichael. Representative Carmichael, you had your hand up. Now it's gone down.
Yes,
So,
thank you.
okay.
Thank you. I was having technical difficulties here. Thank you, Mr. Chairman. Sir, you said in your testimony that the majority of the persons who are purchasing sexual relations have 6-figure incomes. Is that what you said?
Well, let me clarify that for you, sir. There was a study and conducted by researchers in Portland a year ago. They surveyed approximately 9,000 adult males around the country who engage in this type of behavior. And based on the research they conducted during that time, they were able to conclude that about 25% of the entire number of men who engage in this type of behavior account for 75% of the actual transactions themselves. And
right, that's because they're repeat offenders.
Right, they would be high volume purchasers, sure.
Right, and we have ways of dealing with repeat offenders. Go ahead, I'm sorry.
Okay, so I'm not sure if I've answered your question or not, but
no.
That 25% is much more likely to earn over 6 figures in their annual income. That's the research.
Much more likely. So what percentage of the folks who are patronizing prostitutes have incomes in excess of $100,000 per year? Because I can tell you that my experience sitting at docket calls for years is that both sides of this transaction or this activity are typically people who don't appear to have anything near $100,000 a year income. So what is the study? What's the citation? And what is in fact their true number as the percentage of patrons of prostitutes who have a income in excess of $100,000 a year?
Representative Michael, as I'm sure you're aware, participants on both sides of the study are not especially forthcoming with their personal demographic and biographical information. The study itself you can find on a demandabolition.org website. More specific details are available to you there, but what I have shared with you is a summary of those findings. And unfortunately, that's the information I have for you today.
Okay, so your data source is demandabolition.org. Is that correct?
Yes,
I'll
sir.
look it up. Thank you.
Thank you.
Representative Heiberger.
Thank you. This is, you indicated that 3/4 of the offenses in this category are done by a small number of people. Did I hear that accurately?
Yes, sir.
And it would seem then that quite a number of those folks would have second and subsequent convictions. Is that accurate?
Well, you would think. I mean, I believe that's the theory behind the way the law is crafted now, but as a practical matter, because it is a misdemeanor, there's not any kind of focus on enforcing that statute. So I think when we come across individuals who are charged this way, it's usually by happenstance. And because there is a misdemeanor section, and I think you can see this in one of the memorandums that was submitted, just looking at the number of offenders convicted of a felony under KSA 216421 in 2019, there were none. There were absolutely none in the state of Kansas. And I assure you, had this been an area of focused enforcement, and as we move forward, if it becomes one, those numbers will increase. But to have none in the entire state, I think paints a pretty clear picture for what we're talking about. It's a misdemeanor. The traditional attitude towards this from many in law enforcement might be, well, it is what it is, and we have other things to worry about. And I'm trying to change that mentality, and I think this bill would go a long way.
Representative Owens.
Thank you, Mr. Chairman, and thank you, Mr. Kage, for being here. Question for you: as I was reading through your testimony, it appears to focus really on the human trafficking element and those being underage. Do you know what percentage of paid-for sex services are underage versus overage versus an adult? Would be one question. And my follow-up question is, if you're paying for sex with a minor, are there not already felonies attached to that because they are minors?
Yes. To answer your second question first, there are felonies. There are penalties in place for that. Your first question, I'm sorry, what was it again?
I was just curious, because your testimony focuses on those that are underage. Do you know the percentage of studies done where they give an idea of what percentages of paid for sex services are with adult and adult or adult versus child, just for clarity and curiosity?
Right. Unfortunately, I don't have that information for you. The reason why I included that age is because this is the average age that a girl first enters into this profession. And I'm using that to illustrate a point. So let's say, for example, today it's 50-50 or 60-40, whatever the split may be, those underage and those over the age of consent. The fact is, just because she's been doing it for 8 years, doesn't mean that she should have gotten into this position in the first place. If the average age that a girl enters into this is under the age of consent, I think that helps to illustrate the difficulty in what we're dealing with here with regards to human trafficking, and that would be by definition aggravated human trafficking. Anytime within the state of Kansas, and really under federal law now, that you would use a minor child to provide sexual relations in exchange for any kind of consideration, that meets the definition.
All right, thank you. It helps me understand, because I agree 10,000% that anything dealing with underage minors needs to be a felony and prosecuted as such. I may be just a hair bit libertarian when it comes to consenting adults on this issue, but thank you for helping me understand it.
Thank you, sir.
Thanks for your testimony today. I have no other listed proponent testimony. We'll move on to opponent testimony. Representative Coleman, you wish to testify on this matter? And I'm sure I know you're testifying some in committees and that, but I appreciate kind of a summary, not word for word reading of your testimony would be helpful.
Yes, thank you. Mr. Chairman Jennings and members of the committee, thank you for the opportunity to present before you today. If you want to protect women and sex workers of other genders, I ask that you legalize sex work. By pushing this respectable, hardworking profession onto the black market, you cut workers off from justice. When you make something illegal, disputes will be resolved in the streets through violence and threats. Whereas, if you legalize something, it can be resolved through the courts. By criminalizing sex work, you are in effect telling sex workers that if they are facing harassment or payment disputes, they should not be able to petition a judge to issue a remedy. How do we know legalizing sex work is effective in protecting workers? Because it works in other countries. I have in my written testimony put an article from the Harvard Civil Liberties Law Review for you to read. Mr. Chairman and members of the committee, if you want to protect sex workers, you don't have to legalize sex work. Decriminalizing it will produce similar results. An article in The Independent with the headline, quote, "Decriminalizing sex work is the only way to protect women, and New Zealand has proved that it works," end quote, tells the story of sex workers who felt they were empowered to deny certain clientele without repercussion of physical harm. The Independent says, quote, "More than 60% of the 772 sex workers who participated feeling more able to refuse to see certain clients, and 95% said they felt they had rights after decriminalization," end quote. The rights being given back to them meant the balance of power shifted from sex workers and moved away from those who would seek to exploit them. I urge the members of the committee to vote no on HB 2274 and stop trying to drive the sex work industry deep underground into the black market and stop endangering sex workers by making their profession the domain of criminals who seek to exploit them. Thank you for your attention, and I will stand for questions at the appropriate time.
Thank you, Representative. I think you're the sole opponent here, so committee questions for Representative Coleman. Representative Smith.
Thank you, Mr. Chair. Representative Coleman, did any of those studies tell you what the percentage of, or numbers, simple numbers of people involved in human trafficking in those countries?
Yes, actually in the New Zealand case, due to decriminalizing the sex work, they actually were able to eliminate sex trafficking completely.
Eliminate it, so
Yes.
zero.
Yes, in New Zealand, sex trafficking has been eliminated.
Thank you, Mr. Chairman.
Committee, other questions for Representative Coleman? Seeing none, thank you for your testimony today. Appreciate it.
Thank you.
Committee, I have no other opponent testimony listed and no neutral testimony. If anyone wants to say anything, now would be the time. Hearing no one, we will close the hearing on House Bill 2274, and we will move on to our next item of business, House Bill 2360. We'll ask the reviser to provide us a review of House Bill 2360. Ms. Scott, you can proceed.
Thank you, Mr. Chairman. House Bill 2360 removes recklessly causing fear or evacuation, lockdown, or disruption in regular ongoing activities from the crime of criminal threat. The bill amends KSA 2154-15, which is the crime of criminal threat. And the current law, you'll see there, provides those three prongs as to what makes up that crime. We're leaving 2 and 3 alone, but in number 1, we are removing the last bit of that sentence that says, "or in reckless disregard of the risk of causing such fear or evacuation, lockdown, or disruption in regular ongoing activities." And I can take any questions.
Any questions for Natalie? I see none. We will then proceed with Proponent testimony on House Bill 2360. Call upon Clayton Perkins, Legislative Committee member of the Kansas Association of Criminal Defense Lawyers. Mr. Perkins, welcome.
Thank you, Chairman Jennings and members of the committee. My name is Clayton Perkins. I am a public defender who specializes in appeals, and particularly I was the appellant's counsel in the case State v. Botker, which is, I think, why this bill is here today. I am testifying today in my personal capacity and on behalf of the Kansas Association of Criminal Defense Lawyers. So just to give you a little bit of background, the State v. Botker case addressed the constitutionality of these reckless provisions of the criminal threat statute. And in a very brief explanation of the constitutional law there, the First Amendment protects freedom of speech. But there are a few exceptions that have been recognized by the United States Supreme Court to the protections of free speech, one of which is the category of true threats. That category has been defined through a few different cases, one of which was Virginia v. Black, which was a case discussing a Virginia statute in which the United States Supreme Court said, basically define true threats as threats done with the intent to intimidate, meaning when the speaker is saying whatever language is taken as a threat, they are doing it with a mental state to cause some sort of fear or intimidation. In State v. Botker, the issue was Kansas's reckless threats, which allowed a conviction with just the reckless disregard of the risk of causing fear, which is, under our 3 tiers of mental culpability under the Kansas statutes: intentional, knowing, or reckless. Reckless is the lowest level. And it is not the intentional or purposeful language that the United States Supreme Court referenced in the Virginia v. Black, and in the Botker case, the Kansas Supreme Court applied that United States precedent and said that the constitutionally allowable threats are those done with the intent to cause these bad acts. I know the committee is busy and had a lot of things, so I can spare most of my First Amendment lectures. I'm happy to answer any questions about the constitutional issues, the procedures of that case, which is part of why it's here today. And the other point I would just like to briefly mention is that even just the intentional forms of criminal threat include a pretty broad range of conduct, and can often sort of fall outside of where, particularly on the low end of that conduct, sort of the proportionality we have with our grid system and some of the other crimes. And the example I give in my testimony is that you can punch someone and commit a battery, which is a Class B person misdemeanor. But if you tell someone, I am going to punch you, that is a criminal threat. That is a Class 9 or severity level 9 person felony. So on that side of the range, it falls in a very strange category where we're criminalizing with a harsher penalty, saying you're going to do something than actually doing it. And I am happy to take any questions at the appropriate time.
Mr. Perkins, I believe you are the sole proponent here this afternoon. Committee questions for Mr. Perkins on his testimony? Maybe just a little help, if you can, Clayton, a little clarification. Are you suggesting that by virtue of the case that you were involved in with the Supreme Court, that the Supreme Court has effectively stricken the validity of the reckless disregard of risk of causing fear or evacuation from the statute and its ability to be applied?
Yeah, yes, it can no longer be applied. It would, if you charge someone with it, it would be challengeable The only form of the statute that's now enforceable is the language that's remaining, which is the specific intent form.
So in essence, you're saying this is something of a cleanup?
Absolutely, yes. And I did not propose this, but whoever did, thank you for doing it.
I don't recall, and I don't know that it matters, but we'll figure it out and convey your thanks to them. Committee, any other questions for Mr. Perkins? Representative Heiberger?
Revisor question at the appropriate time.
It's always appropriate to question the reviser.
Okay, well, I guess I'm just looking in the description of the bill in the agenda and on the House calendar day. I was just wondering if you could, Natalie, you could tell us what evacuation is.
Mr. Chairman, that's a misspelling. I think it's actually been corrected by now, but I'm guessing that when this agenda was created, it was still wrong. So that's my mistake.
That's supposed to be evacuation.
Evacuation. Yeah,
Okay,
evacuation.
that's a little more clear. Thank you.
Yep.
Any other questions for Mr. Perkins or Ms. Scott? I don't see any. Thank you, Mr. Perkins, for your testimony today. We appreciate it. Are there others appearing as proponent on this bill? I see none. I have no opponents listed. Anyone wishing to testify in opposition? I see none. I have no neutrals listed, so and no neutral people screaming or yelling or waving their hands. So we will close the hearing on House Bill 2360 and move on to our work this afternoon as it relates to matters previously heard and scheduled for consideration today. By way of information, House Bill 2346 is going to be passed on for today and will be brought up tomorrow. There's some ongoing conversations around that one. Would like those to have the opportunity to occur and see if there's any amendments that might rise out of those conversations. We will move on for consideration of House Bill 2146 and ask Natalie that you refresh our recollection about this bill.
Thanks, Mr. Chairman. House Bill 2146 expands the number of presumptive probation boxes and border grid boxes in the sentencing grid for drug crimes.
Committee, any questions for the reviser? Very well. I do have an amendment that I would like to. Oh, I'm sorry, Representative French. I'm sorry, didn't mean to get ahead of you. Go ahead and ask your question.
Thank you. Yeah, my only question was, what is the primary purpose of this this bill? Why are we doing this, basically? Does anybody have an answer to that for me? Thank you, Mr. Chairman.
Natalie, can you tell us, I guess, what the bill does, maybe in some other words?
Sure, Mr. Chairman. I don't typically speak to, as to why a bill is requested, but I can kind of summarize some of the testimony we heard to say that the people who brought this bill forward believe that this proposed grid reflects more closely what is happening now with sentencing, whether someone is being sentenced to probation or prison. They're just going through the departure process to effectuate that goal. So that's kind of what you heard in the testimony, at least.
And so this is a lessening of the penalties for these crimes, is that correct?
Well, Mr. Chairman, it doesn't reduce the amount of time that a person is sentenced to, but it makes changes to the presumptive disposition of the case. So when you look at the sentencing grid, all those boxes either have a white background, which means that they're presumptive imprisonment, or a hash marked background, which means that they're a border box, or they have a gray background, which means that they're presumptive probation. And so it doesn't reduce the amount of time that a person either spends incarcerated but it does reduce what that, we call that usually the dispositional part of that sentence as to whether they're going to be incarcerated or be on probation.
Thank you. That explains it. Thank you very much, Mr. Chairman.
Natalie, kind of a follow-up on that. So when we expand opportunities for probation on drug offenders like this, the low-level drug offenders, does that create a scenario where they may become eligible for community-based treatment in lieu of incarceration under, say, the current scheme? Is there any opening of that opportunity as a result of those shifts?
Mr. Chairman, I don't know what exactly is available in each jurisdiction through each judicial district. Absolutely, someone who gets sentenced to probation, that sentence also comes with certain types of drug abuse treatment. We do, as you guys all are well familiar with by now, have a certified drug abuse treatment program at the state level. We call that Senate Bill 123. The eligibility for that program is in the Senate Bill 123 statute, but a lot of times when we make changes to the grid that can affect who might get probation, we typically in turn make some changes to the Senate Bill 123 program to allow those new people who might be eligible for probation to participate in that program. And that is what we have done here in House Bill 2146.
Appreciate that. Thank you. Committee, other questions for Natalie on this bill? Very well. I'll go ahead and ask that Natalie and Kim distribute to the committee an amendment. And as that's being distributed to you, I would like to share with you that we know that we had testimony regarding both House Bill 2139 and House Bill 2146. Similar kinds of things contained within those relating to presumptions of probation and border boxes and sentencing generally around drug offenses. And we heard from the law enforcement community about some concerns they had. I did spend time following hearings on these two bills, thinking and working on developing something that perhaps the committee might be open to considering, and that law enforcement community would see as something that they would not feel quite so bad about. And in those communications and in that work, it is my belief that the amendment that's being offered has achieved that. I believe included in your email, and I've got to jockey around with all my stuff here. It's handy, but yeah, nice to have 6 screens. In addition to the balloon amendment, and probably the easiest way to actually explain the amendment is really taking a look at these sentencing grids that are a second attachment there. And what I've sought to do is to depict for you with color coding to make it really easy to follow what was offered, what the current law is, what that current grid would look like, both values and color coding, what was proposed in House Bill 2139, and what was proposed in House Bill 2146. And then I worked around with that a little bit and thought that perhaps something scaled back in some ways and maybe expanded in others, I guess, when you look at it, but it was really an effort to kind of push down the level of change from the top and move it a little bit of left to right. And as you look at these, you can see that it definitely expands by one column on the level 5s, presumption of probation. That would go to people that includes one person felony, would still be now considered a presumed probation. On that same level 5, moving the border box over 1, which is that discretionary point for the courts to go either way. And then on the second level of drug offenses, creating for level 4 drug offenders the potential and presumption of probation with no more than one non-person prior felony or misdemeanors, and then over to the column of one person felony really stays the well, it expands over to the left to one person and one non-person felony on the border box section. On the level 3s, no change, which is different, obviously, than what was proposed in House Bill 2146. It does capture the elements of some incremental reduction, although it's actually an increase from current on the one misdemeanor. There's a slight increase in prison sentence by basically a month. But there's an incremental decrease in prison sentence for the level 5 possession people on prison sentences across the grid. So I tried to paint a picture of here of, how it is now, what these two other proposals suggested they thought it should be, and then kind of a hybrid version of that. This was provided to the law enforcement community's lobbyist, Mr. Klump. We've had discussions back and forth, and basically at the end of the day, his words are, we accept your proposal as a compromise. So it seems as if maybe we were able to find kind of a sweet spot where law enforcement can feel more comfortable with the changes. I want you to know in my conversations with Mr. Klump, and he is a representative of the law enforcement community, at least in this body, they truly believe that treatment is a very appropriate intervention for a good number of offenders, not all, clearly, but they agree that obtaining treatment and changing that behavior through effective treatment modalities will lead to a longer-term better society as a whole and less offending by those people on an individual basis, and that I believe he would suggest that this helps move us in that direction, opening up some treatment options that might otherwise not be available to others. It does also have an impact on prison beds, and I will say it's not all about how many prison beds we use. I think the question really is better asked of the beds that we use. Are they beds that we ought to be using? Are we doing what we should in the criminal justice system, provide for public safety, not only the short term, because I think public safety is easy when you lock people up in prison. They're not a problem to the public anymore. But all of these people, all of these people on these grids, they're all getting out. And the question becomes, can we be more effective in changing behavior through less dependence in some cases on prison and more connection to community options. And an amended bed impact statement, Sentencing Commission is suggesting that with this amendment, so I shared this amendment with them to see what's it do, you know, what's the impact going to be. They have reported that this bill would reduce prison admissions in fiscal year 2022 by 240 admissions and 265 out that 10-year span to 2031 each year. That it would save approximately 228 beds of prison space in fiscal year 2022 and 277 prison beds in fiscal year 31. It would increase the number of probationers by 242 and 265, and the impact on Senate Bill 123 treatment that you would anticipate in just round numbers, it's $302,000 additional for fiscal year 2022 to be able to provide the treatment services at the community level, and as opposed to having these folks in prison at the whatever rate you choose, $25,000 a year or something such as that. And so it would seem this kind of touches on a lot of different issues, but it does advance the notion that treatment is important. And then just for what it's worth in the commentary section of this, I've heard the Secretary of Corrections say it so many times now, it's just burned in my mind. You know, he will tell you that there are two capacity issues. One is, how many beds do you have and how many bodies can you put in those beds? That's one capacity issue. But the second capacity issue really goes to the capacity of the institutions to provide the programming and services necessary to actually change behavior in the long term. And they don't have that capacity because their capacity is being absorbed by the number of bodies. The resources are directed towards day-to-day operations, taking care of them. And I know last year, we had testimony in this committee last year, I believe it was, that suggested that inmates who are assessed with respect to substance abuse issues in the prison system, that 50% of those who are diagnosed with a substance abuse disorder that was deserving of treatment do not receive that treatment while they're in prison. And I guess unless we find some equilibrium here along the way, unless we're ready to plow a whole lot more money into the existing system, if we can get some capacity relief in one way, my absolute hope would be that we could increase the capacity to treat those who are identified in need of treatment prior to their release back to the community while you've got a captive audience. I just think it's a terrible missed opportunity, and I'm not sure exactly how we swing that in the end, but I do think that this is one strategy that can be used that might well provide for better public safety. And the last point on this I would say to you is, I'm a big believer in incrementalism. I kind of see it not as pilot projects as such, but you know, let's do this a little bit. Let's see what the data tells us in another year or two. If this works well, and if we in fact have not provided a greater risk to public safety, and if in fact we're beginning to have inroads with offenders in much more positive ways, then we have the conversation about what are the next steps. You know, are there opportunities in the future to do more in different ways? But I see this as being not really a first step, because the really first step was back in 2003 or whenever Senate Bill 123 first came to pass. That was the first experiment. And we really have, over time, increased accessibility to those. And I think, in large part, we have achieved some success. We've had discussions here yesterday about specialty courts and drug courts and a therapeutic approach to justice that's proven to be very effective. If we can get a grip on this substance abuse side, you know, we've still got a lot of work to do with the mental health side of all of this, but I think there's an opportunity here. So that's, I mean, my explanation of the amendment is, yeah, it expands some probation boxes, it expands some border boxes, and incrementally reduces long-term prison sentence at the far end by 6 months on those 3+ person felonies, 6-month reduction compared to 42 months max, it'd be 36 months max. And that's what this amendment does. So questions, or I guess, is there a second on the amendment? I should ask for that before we get into too much more discussion. Representative Heiberger, you second? Motion's been made and seconded. Representative Owens.
Two thoughts that I would add. One, not necessarily speaking to this amendment, just a comment that you made. I am pleased to report that in the Department of Corrections budget, there is the money to create 250 beds within an existing facility to treat all of the untreated that are currently going through are incarcerated. So that was in the budget. It passed last year, was yanked out due to COVID, and is back in the budget, and I'm optimistic that that will pass. That being said, the only other thing that I wanted to just make specific mention on this bill is that this only applies to the drug grid. So we are specifically dealing with drug-related offenses in this scenario. So that's all. Thank you, Mr. Chairman.
Representative Smith.
Thank you, Mr. Chair. In your very comprehensive and detailed explanation of how this all works, I thought it would give it a little validity from the law enforcement side of things, and some might even question, why is it so important that law enforcement have a position on this? And I would offer that anytime you start messing with the drug grid or the sentencing grid, you're also, you are affecting, you're impacting the very beginning. So from the time we receive information about or a complaint that something is occurring to the time that we do the investigation and then subsequently decide whether to make an arrest, there's some discretion involved. What is the severity of what we're watching? What is the severity of the impact on society? And what good do we do now? Then with any experience in that, you see it passed on after an arrest, a possible arrest, you see it passed on to the court system, and you watch what happens with the court system. Having watched that several times, you might imagine in my career, you do get a little bit gun shy when somebody says, hey, there's not enough to support keeping this intact, so let's move it. And so that's what created the conversation. That's what created the, and I want to say this to the committee, I appreciate the chairman reaching out to law enforcement and being willing to not only let us talk, but also to accept that some of the things that we're offering had value, and I appreciate that. We're not waving pom-poms and saying great deal, but at the same time, we take into account that there may be some value, and I like the idea that you put across on incrementally. I think that idea is something that I can hold on to and say, yeah, I agree, if it's something that we can revisit. But I would also tell the body that there are some things happening in other committees right now that this will indirectly impact, if not immediately. If we pass this out and then other things that are happening in other committees pass out, there will definitely be a, maybe not so visible to the layperson's eye what's going on out there, but certainly the number of violations and the amount of traffic that is happening in the courts as a result of that. So just keep in mind that the butterfly effect begins somewhere, and it may be here. So having said that, I think I'm going to go ahead with the amendment and support it.
Committee, other discussion? Representative French.
Thank you, Mr. Chair. And I am of the opinion that I agree with your intent that rehabilitation should be exploited as much as possible for these drug offenses. I wish I had as much faith in them as you do, but it's just a simple balance of rehabilitation versus incarceration. But with due respect to you, Mr. Chairman, I will agree to this amendment. Thank you.
Thank you, Representative. Representative Heiberger.
Thank you, Mr. Chair, and I too will support the amendment. I was hoping we'd go farther, but I really do appreciate the work you've put in. I mean, at the risk of alienating anybody who's going to vote for the amendment, I will express a little frustration that we've seen a number of proposals this time that have come through balanced committees like the Criminal Justice Reform Commission, Sentencing Commission. For all sides have gotten to weigh in, and we come out with a compromise project, and then we get to this committee and we compromise again. So I'm mildly frustrated with that, but I will support the proposal.
Other comments? Committee Representative Carmichael.
Thank you, Mr. Chairman. I appreciate the chair's hard work and the cooperation of Kansas law enforcement in reaching something that looks like it has a good chance of passage. But I would echo the words of our ranking member that we compromise before the final recommendation comes to the committee. And then we compromise a little more. But as you see on the floor today, it doesn't really always work the other way around, that once someone announces they've reached a compromise in the Judiciary Committee, for example, it becomes gospel and binding on the body. And so if we compromise here, as I think we should, I hope we won't do away with the good effects of this legislation on the floor through further compromise here, or heaven forbid, with our colleagues in the Senate. But again, I commend the chair and everyone involved, and I certainly intend to support this bill. Thank you.
Any other comments on the amendment? Sure, Representative Owens.
Thank you, Mr. Chairman. Just speaking to both of my colleagues, most last comments, one thing that I've learned, having had the opportunity to work on the Criminal Justice Reform Commission, I've been able to study this stuff for 2 years, right? Not as long as some people that have lived it in law enforcement, and not as long as you who have lived it your whole career, but for 2 years I've lived kind of in this silo. And so I have a very different understanding than even some of the people in this committee. And then you could take that and amplify it by 10 times for the people that are in our body. Because the people in our body aren't studying this stuff at all. They don't understand it whatsoever. And I think that's where these compromises become very valid, because I think you, Mr. Chairman, recognize that while Representative Heiberger's arguments are correct, there was compromise in the committee to get here, that if we don't compromise a little bit more, there's really no way to convince our body to take even the smallest steps, because they're not living in this silo. And that's why I think sometimes the incremental steps are the best approach, because that's much more palatable to people that aren't spending their entire legislative careers focusing on this topic. So just wanted to share that context or perspective. Thank you.
Committee, further discussion? Well, in closing, I would just say that I expect that members of the body who are not involved in this committee process on a regular basis, frankly, have a much lesser depth of understanding or knowledge about the subject matter that we sit in here and talk about every day. And I know that there are members that come in here knowing nothing at the beginning of their legislative careers, and as time goes on, they begin to learn more, and some of it probably pleases them, and some of it probably horrifies them when they really start digging in. I just believe that that treatment is a potential. It's not a guarantee. It never will be a guarantee. But it is a potential that can lend itself not only to a change when it works well for that particular offender, but it has a generational impact. When you have someone who has been pulled out of the jaws of addiction, they get on with a life and they're able to raise their family in an environment that isn't filled with addiction and the violence and the things that go with that, their children have a better chance of not suffering from addiction and a better chance of being successful than had we not done anything. And the potential for generational impact is significant. So while we may not see all of the impact, in our lifetimes with offenders, I guess you have to hope that in the long term, the planet becomes a little better place because we've got some people that otherwise would have gone down that path, hardly without a doubt, that maybe don't. So with that, I will close on my amendment and move my motion. Those in favor of the amendment, please indicate by raising a hand. Very well. We have a significant majority. Those voting no, you can raise a hand. Those voting yes who would like their votes recorded would include Representative Carmichael, Representative Heiberger, Representative Owens. Any others wishing to record your affirmative vote? Representative Carmichael got you. Anyone with a no vote wishing to be recorded? Seeing, hearing none, we will move back to the bill as amended. Are there further amendments or further discussion on the bill as amended? I see none. Committee, then, what is your desire as to House Bill 2146 as amended? Representative Heiberger.
Mr. Chair, I move that the committee recommend House Bill 2146 as amended favorably for passage.
Is there a second to the Heiberger motion? Representative Resmond. We have a motion and second to recommend favorably House Bill 2146 as amended. Those in favor indicate by raising your right hand, or a hand. How's that? No confusion there. Those opposed, the ayes appear to have it. The ayes do have it. Those wishing to have their affirmative vote recorded would include Representative Carmichael, Representative Heiberger, Representative Owens. Any others wishing to have their affirmative vote recorded? See none. Any wishing to have a nay vote recorded? See none. We will move on then. We're now on to House Bill 2374. Natalie, would you be so kind as to refresh our recollection about House Bill 2374?
Yes, thank you, Mr. Chairman. House Bill 2374 authorizes the Kansas Sentencing Commission to change the risk assessment cutoff levels for participation in the Certified Drug Abuse Treatment Program and for supervision by Community Correctional Services. And I can take any questions.
Committee, any discussion or amendments on House Bill 2374? I had mentioned yesterday that this might be fair game for consent calendar. Now that we're at Wednesday, I won't have it submitted until Thursday. And the potential, as I look at the number of bills, unless they really grow in number, we might not be here beyond Wednesday or even to Wednesday of next week if God was willing. It might be a high-risk play and have it die on consent calendar. So I would be inclined to discourage any motion to place it on consent calendar. It will be, I think, a rather summary proceeding. Are there any amendments to be offered here? I see none. What's the will of the committee on House Bill 2374? Representative Heiberger.
Yes, Mr. Chair, I move that the the committee recommend House Bill 2374 favorably for passage.
Is there a second on the Heiberger motion? Representative Owens seconds. Any discussion? Representative French.
Thank you, Mr. Chairman. Maybe Natalie can help me with a question I have. Under the impact assessment we had, it said in FY 2019, we had 1,478 offenders who were sentenced to mandatory drug treatment probation under 2003 SB 123. I was just wondering how many more would be added because of this bill, if you might know that. Probably may not. Thank you.
Yeah, Mr. Chairman, I'm sorry. That is not something that I would know. The Sentencing Commission puts those bed impacts together for you, so that would be something we might have to ask, Scott about.
My only concern is that we're maybe overtaxing the SB 123 program, and I just want to make sure that we do have the funding to handle any additional requirements of that particular program.
Are you on, Scott? I don't see you listed if you are. I guess I would share this, Representative. The purpose of this bill, as I understand it, is that currently the Sentencing Commission uses a particular instrument in assessing substance abuse need. So that's the tool that they administer to offenders, and they administer the same tool to both male and female offenders right now. And what this proposes to do is to go ahead and use a different instrument, still a valid instrument for assessing substance abuse need, but one that will be specifically for males and one that will be specifically for females. Evidently, there are factors within different genders that may influence substance abuse addiction issues, and that this is the sorting tool that is used to determine those who are in need of treatment. I suppose the potential would always exist if we're using a more current and a more valid instrument. It might suggest there could be more people in need of treatment, but I think you could say the same thing about it going the other way. The potential of screening people in or out of treatment need, I guess Scott would probably say would be more accurately accomplished in this way and not necessarily result in more clients necessarily. I honestly don't know that that could be answered until you actually use the instrument against our population and see what happens. I certainly understand your concern, but I don't believe there's been any concern raised by the Sentencing Commission about a capacity issue because of this change.
Mr. Chairman, I would also, Scott just sent me an email, so I'm going to read that to you guys. He said, "We are okay with the changes to Senate Bill 123. The commission was mindful of this and will attempt to operate within current appropriations."
I don't know, I just had the impression that this was going to add to the 123 program. May just be a bad assumption on my part, so I'll let.
And evidently, if it does, they've already made a decision that it won't be enough adding to it to impact their fiscal ability to meet the demands. So that's kind of good news. So if there is an impact, it sounds as if they feel they can meet that impact. Other questions, committee? See any? You want to go ahead and close in?
I close and move my motion.
Committee, you've heard the motion to recommend House Bill 2374 favorably for passage. Those in favor raise a hand. Those opposed, same sign. Motion passes, and affirmative votes will be reflected in the minutes for Representative Carmichael, Representative Heiberger, Representative Owens. Are there others wishing to have their affirmative vote reflected in the minutes? I saw no votes, so I don't think there's any to reflect, but if you wanted to vote no and you want it reflected, now would be the time to speak up. All right. We are going to, as I say, pass over on 2346. That will be on tomorrow's agenda. We have the balance of bills that we're going to take care of prior to turnaround tomorrow. I believe we will be able to wrap up our work tomorrow if we work with some dispatch, but certainly doesn't have to be hurried. Just a preliminary number before we go today, because I hadn't really stopped to take time, and it does not include the work that we did today. But to give you a sense of the intensity and workload of this committee, and you look at other committees, and they don't have 3 pages of bills. You know, we've got 3 or maybe even up to 4 bills now. In this committee, we had 43 bills assigned to this committee thus far this session. Of those bills, before today, we'd had hearings on 26 of them. 14 bills have been recommended for passage and sent on to the calendar as of end of yesterday. 6 of the 14 that had been recommended had already passed the House and are over to the Senate. And there are 19 bills for which no action has been taken this year in terms of final action. And that would include a couple that we know have been kind of blended into one bill. We did that today. So, but I would just say to the committee, under very difficult circumstances, this committee, I think, has functioned at an extraordinarily high level. I appreciate the openness and the willingness of the committee members to engage and have conversations and to find consensus where we can, and to acknowledge that there will be times we don't agree, and that's just the way it is, and that's okay. I appreciate everybody's participation. I appreciate your unique experiences and perspectives, and I hope you will appreciate that we're out of here 23 minutes earlier than we otherwise would have planned on and got some work done. So with that, we will adjourn and see you all tomorrow.